On April 5, 2019, Tyler Griffin was subjected to an aggressive enforcement encounter by Officer Donald Vickers and Officer Matthew Abad of the Atlanta Police Department in Atlanta, Georgia. The officers tailed Mr. Griffin in an unlit, unmarked vehicle for several blocks under the pretext of traffic violations, though the department produced no dash camera footage to substantiate those claims. Following the takedown, body camera footage captured Mr. Griffin immobilized in intense pain, while the officers laughed and made jokes regarding marks on the ground, completely ignoring that the force of the impact had severely fractured his ankle. Officer Vickers' conduct occurred despite a documented history of excessive force, which included a 2011 disciplinary action for pepper spraying and kicking a handcuffed civilian. Mr. Griffin subsequently filed a federal civil rights lawsuit against the individual officers and the municipality in the U.S. District Court for the Northern District of Georgia. During the discovery phase of the litigation, plaintiff's attorney Matt Kahn of the Butler Law Firm identified the structural discrepancies in the administrative files and called for a formal corporate deposition. On September 22, 2020, Attorney Kahn deposed Sergeant Quentin Reese, who was designated as the official representative for the City of Atlanta under Federal Rule of Civil Procedure, to answer for the department's evaluation policies and personnel oversight.
Can you tell me what is the general purpose of the performance evaluations?
Purpose of a performance evaluation is to give the officer and the department an understanding of where the officer is in regards to what their terminal objectives are for their evaluation.
Is it fair to say that one purpose of performance evaluations is to measure police officers' competencies?
I would say that's fair.
Is it fair to say that one purpose of performance evaluations is to encourage police officers to comply with the standard operating procedures?
Yes, I'd say that's fair.
Is it fair to say that one purpose of performance evaluations is to identify performance problems?
It is.
If a police officer violates a standard operating procedure, is that something that would appear in the performance evaluation?
No, not necessarily.
Well, let me ask you this: if a police officer violates a standard operating procedure, is that something that you think should appear in a performance evaluation?
I think a performance evaluation is an overall rating, not based on one particular incident.
So it's your opinion then that one violation of the standard operating procedures is not enough to affect a performance evaluation?
I think it depends on what the SOP is that's violated.
That's fair. So what's an example of an SOP that could be violated that would be enough to affect a performance evaluation?
Excessive use of force would be one. Excessive tardiness would certainly be, or tardiness or absence from work would be another.
Could you think of any other examples of like a singular rule violation that would be enough to impact a performance evaluation?
Off the top of my head, I can't think of any. Again, performance evaluations are used as a tool to measure a whole of a year's activities, not generally just one incident.
Okay. Well, so how many times does a police officer need to break the rules for it to be noted in a performance evaluation?
I can't set a number. I wouldn't be able to tell you that.
So I guess is what you're saying, that it's sort of a case-by-case basis depending on the number of violations and the seriousness of the rules that have been violated?
I would say that's fair to say.
If a police officer has a pending OPS investigation, is that something that would be noted in the performance evaluation?
No,
Why not?
it's generally not recorded there. Again, it's a totality of all of the activities. It's not something that's singled out in a performance evaluation.
But would an OPS investigation be considered in the performance evaluation?
I would say it would probably be taken into account by the rater who's rating the officer.
So an OPS investigation would be taken into account by the I guess the person giving the evaluation, but would not be dispositive on any one issue. Is that fair?
Yeah, I would say that's fair.
Okay. If an OPS investigation finds that an officer actually did break the rules and there's an adverse finding, is that something that would appear in the performance evaluation?
Again, performance evaluations do not necessarily take into account individual activities. It's a totality of all of their actions and activity for a year. Now, a rater may have in the back of their mind, yes, this officer's had numerous OPS packages this year, and they are aware of the findings of those OPS packages, and certainly that would be a factor in the rating that they would be giving the officer.
Okay. Well, doesn't an adverse OPS investigation relate to an officer's performance?
It does.
So then why not include it in the performance evaluation?
It's just not something that's added to a performance evaluation. It's taken into account based upon the knowledge that the supervisor has over that officer. And again, it's the totality of all of their actions for that year. I don't foresee any supervisor saying this officer had all of these complaints, et cetera, and then giving them a highly effective rating. That just doesn't happen. I haven't seen it happen.
Okay. Well, would you agree that a performance evaluation of a police officer who repeatedly breaks rules should reflect that?
I think that would be reasonable that you would see that in their performance evaluation.
But would you agree that in order for a performance evaluation to mean anything, it must include instances in which a police officer breaks the rules?
I think that a performance evaluation should take into account all of the officer's actions and activities, and it should be a fair representation of who that officer is.
Is it fair to say that if a police officer repeatedly breaks the rules but gets positive performance evaluations, the city is condoning the officer's rule breaking?
Objection, but you can answer.
I don't know that that is taking place. I would certainly not want that to be the case.
If that were the case, would you agree that the city is condoning the officer's rule breaking?
Objection, but you can answer.
Yeah, I would say that's not right.
Sergeant Reese agreed with Mr. Kahn's premise regarding institutional accountability under the framework of the landmark 1978 Supreme Court case called Monell versus Department of Social Services of the City of New York, conceding that if an officer repeatedly breaks departmental rules but is rewarded with positive performance evaluations, it would mean the city is condoning the officer's rule breaking. Under the Atlanta Police Department's standard operating procedures, known as SOPs, officers have a mandatory duty to comply with all departmental rules, regulations, and competency metrics. While an officer may occasionally violate an SOP, the department does not automatically penalize their entire annual review for a singular infraction unless the violation involves severe misconduct, such as the excessive use of force under color of law. In this case, Mr. Kahn questioned Sergeant Reese about how officer misconduct is documented. Sergeant Reese confirmed that a police violation does not always appear in the performance evaluation. The evaluation relies on the totality of the circumstances over a year, serving as a holistic summary of the officer's overall performance, competencies, and conduct across the entire year. Regarding general police procedures, the Office of Professional Standards, known as OPS, is responsible for investigating internal violations. The police department structures its performance evaluations so that pending OPS investigations are not explicitly itemized or detailed within the evaluation document itself. However, Sergeant Reese acknowledged that a supervisor will take their own knowledge of sustained OPS findings into account when determining the officer's final overall performance rating.
If an officer received an early warning review, is that something that would go into a performance evaluation?
I think it would be one of the factors that goes into a performance evaluation.
Are you familiar with the criteria for the early warning system?
No, not off the top of my head. I would have to recall SOP.
All right. Excuse me. I'm going to share my screen with you. All right. Can you see Plaintiff's Exhibit 33 on your screen?
I do.
And it's a 6-page document, so I can scroll through it if you like. But does Plaintiff's Exhibit 33 appear to be Defendant Vickers' performance evaluation for 2019?
It does.
And have you seen Plaintiff's Exhibit 33 before?
I have. It's in his performance evaluation that in his personnel file that I provided.
And do you see the highlighted evaluation period that says or begins July 1st, 2018 and extends through June 30th, 2019?
I do.
And that would include the date on which Vickers tackled Mr. Griffin, wouldn't it?
Objection. You can answer if you know.
I don't know. I don't know anything about the case, so.
Sure. So April 5th, 2019, and any conduct by Mr. Vickers on that date would be within this period, correct?
It would be.
All right. So we'll flip to the second page here. Do you see the first goal of APD is CARE, C-A-R-E, and it says represents the department in a courteous and professional manner?
I see that.
And then you see under the goal, there's a comment section, right?
Correct.
Isn't it true that the person performing this evaluation can put anything they want in that comment section?
They can.
For example, if the officer being evaluated was not courteous and not professional, the reviewing employee could say that in the comment section, right?
Correct.
Do you see where it says works with a sense of urgency, treats everyone fairly and with respect?
I do.
And the reviewing officer gave Vickers a 4 here, it looks like. Is that right?
Yes, sir.
And we'll go back up to the first page with the key. It looks like a rating of 5 means exceeds, excuse me, that's wrong. A rating of 5 is outstanding, which is basically perfect, correct?
Correct.
And then 4 would be highly effective, which basically means that the officer did a really good job. Is that right?
It does.
So if APD had thought that Vickers was not courteous or professional, it should have said that in this comment section right here, right?
They could have used that space to denote that.
All right, I'm going to go down. Can you see goal 4 on your screen?
I do. It says professionalism.
Okay. And do you see in the comment section that first sentence that says displays concern and empathy when interacting with citizens?
I see that.
And do you think that that's true for Vickers?
I have seen him empathize with people before. He can be very sensitive.
How many times have you seen Mr. Vickers be sensitive?
On several occasions, particularly with children.
Okay. And so in this category for professionalism, the reviewing employee gave Vickers a 4, it looks like, meaning he did a very good job, right?
Yes, sir.
So if during this evaluation period, Vickers had not displayed empathy when interacting with citizens, Sergeant Davis, who I believe did this evaluation, could have put that right here in the comment section, right?
Whoever the rater was could have put that there, yes.
All right. I'm gonna show you a couple videos.
What's wrong with you, man?
My left foot is.
What's wrong with your left foot?
It's tangled or something. I don't know.
It's got what?
A lot of weight on it.
Just a little bit.
A little heavier when drunk too.
That's all right, man. Abad went to get him out of the car, and Abad's kind of like, "What are you doing?" And Abad's like, "Put your hand behind." He did Abad like that. I did like 50.
Right. Hey man, come on, man, get on up.
Here's his skid marks.
Oh, get up, come on. I help you get up, come on.
We're laughing because you fell pretty hard after pushing an officer, man. I find that funny, man. You don't
Yeah,
touch
that's
officer,
real
man.
funny.
You don't
I
touch an
won't
officer.
do that.
Yo, you
That's
did do
bad.
that.
Sergeant Reese, did you hear Officer Vickers bragging about how he did like 50 and tackled Mr. Griffin?
I'm going to object to this entire line of questioning. But if Sergeant Reese answers, it'll be in his personal opinion.
I didn't hear him say he went 50. I mean, I didn't hear that comment. I was looking at the video and I didn't hear him say that. He may have said that.
Well, did you hear Vickers point out the skid marks and then laugh at Mr. Griffin as he sat on the ground?
Same objection.
Did hear him say something about skid marks, and I heard him laughing. Yes, sir.
That's not very professional or courteous, is it?
Same objection.
No, it's not very nice to behave like that at that time.
Did you hear Vickers say, "We're laughing because you fell"? Let's see. Sorry, we're laughing because you fell. Sorry, let me just start the question over. Did you hear Vickers say, "We're laughing because you fell pretty hard after pushing an officer, man"? I find that funny, man.
I heard him say it. I heard him say it.
And that's not very courteous or professional either, is it?
Same objection.
It's not very nice. No.
Do you think anything that you saw in that video is funny?
Same objection.
No.
Does the city of Atlanta allow its police officers to hurt citizens and then laugh at them?
Same objection.
No.
Do you think that Vickers displays concern for citizens in Plaintiff's Exhibit 2.2?
Same objection.
Can you repeat the question?
Sure. Do you think that Vickers displays concern for citizens in Plaintiff's Exhibit 2.2, which is the video you just watched?
Same objection.
He said he was concerned about his ankle or foot, so he shows some degree of concern, but his behavior is, we would have a discussion.
And what would that discussion be?
The discussion would be about how you talk to people and how we carry ourselves on a incident scene.
And do you think that Vickers displays empathy in Plaintiff's Exhibit 2.2?
I don't know. I mean, to some degree, sure, he's concerned about the guy's injury. He wants to know what's going on with him. Is he being smart with him? Probably so.
Under the landmark standard set by the Supreme Court in City of Canton versus Harris, 1989, a city's systemic failure to supervise or discipline its police force constitutes actionable deliberate indifference if the department ignores obvious risks to citizens' constitutional rights. And in Georgia, by the binding 11th Circuit precedent Gold versus City of Miami, 11th Circuit 1998, it demands explicit proof that a municipality had clear notice of a persistent, recurring pattern of prior officer misconduct, but consciously chose to take no corrective action. To satisfy these strict constitutional frameworks, standard municipal policing protocols and department SOPs impose an affirmative administrative duty on an officer in command to formally discipline subordinates when they engage in actionable misconduct. This framework dictates that a performance evaluation must accurately record an officer's documented behavioral deficiencies. Mr. Khan questioned the department's methodology regarding the application of uncritical, highly favorable notes to an officer's file during a period when they demonstrated severe deficiencies in duty performance. This line of questioning exposed a direct contradiction. Supervisors grading an officer as highly effective in empathy and public interaction during the exact time frame that body camera evidence captured the officer mocking an injured non-resistant citizen.
Oh, shit! Oh! Oh, my God. Oh, my God. Oh, my God. Help me, please. Oh, God. Oh, God. Oh, God. Help me, please. Oh. Ooh. Shit. Oh, my God. Ah! Ah! Oh, my God. Oh, my God. Help me. Oh.
Did you see Abad making Mr. Griffin walk around on a broken ankle?
I saw Officer Abad walking him. I didn't know if he was making him walk. I saw him walking with him, yes.
Did you hear Mr. Griffin cry out in pain?
I did.
Did you see Abad roll his eyes at Mr. Griffin's crying?
I didn't see him roll his eyes.
Let's take another look at that video.
Wow.
Oh, shit! Oh! Oh, my God. Oh, my God. Oh, my God. Help me, please. Oh, God. Oh, God. Oh, God. Help me, please. Oh. Ooh. Shit!
Do you see the eye roll, sir?
I do see him roll his eyes.
Abad didn't seem very concerned about Mr. Griffin, did he?
Objection. You can answer if you know, Sergeant Reese.
I don't know whether he was concerned about it or not. It seemed like he had reservations about whether the gentleman was really injured or not.
Well, Abad wasn't being very sympathetic, was he?
I don't know whether he felt like he was being sympathetic or not. It seemed like he felt like the individual was probably playing a game with him. At least that's what the video seemed.
Would you say that he was being empathetic to Mr. Griffin?
I don't even know how to answer that question because I don't know whether he felt like he was being empathetic or not. Obviously, he didn't make him continue to walk. He should certainly not force him to walk on an ankle if that is in case broken. And I don't know whether it was or not.
So it's your testimony that once, and if I'm mischaracterizing it, please let me know, but is it your testimony that once Abad learned that Mr. Griffin was hurt, he should have stopped making him walk around?
Objection. You can answer, Sergeant Reese.
It's not the policy of the Atlanta Police Department to force somebody to walk when they're injured on an injury. We don't do that.
That's not something that should happen in the United States of America, is it?
Objection, you can answer.
That's not something.
Can you tell me what an empathetic police officer would have done in that situation?
Empathetic police officer would have been able to determine whether or not the individual was telling the truth that they actually have an injury. I've been on many calls where folks profess to be injured and they're not. I think ABAD was trying to determine that. At least that's what it looks like in the video. And then an empathetic officer would call for what we refer to as a 4 or Grady in order to come and treat the individual.
And I'm gonna share my screen with you one more time. Can you see Plaintiff's Exhibit 30 on your screen?
I do.
Have you ever seen this X-ray scan before?
I have not.
Would it surprise you to learn that this is an X-ray of Mr. Griffin taken that night?
I'm surprised by it? No, because you're showing it to me, but it looks like he's got a few pins in his ankle. Looks like he probably had a broken ankle.
Would you agree that it'd be pretty messed up to make someone walk around who had that sort of injury?
Yes.
All right, I'm going to show you another video clip. So just for the record, this is, can you see the screen right now?
5.2.
For the record, this it should be Plaintiff's Exhibit 5.3. So that was a labeling mistake. But so what the video I'm about to show you ought to be Plaintiff's Exhibit 5.3.
So when he got to the back here, what was he doing?
Trying to turn around. He got
Yeah.
stuck in the gravel. And
Yeah.
if he wasn't stuck in the gravel, he would have ran me over because he
Yeah.
kept hitting the gas.
Yeah.
And I was stuck.
Yeah.
I damn near shot him. I was about
Yeah.
2 seconds before bullets in his window.
Sir, did you hear Abad say, quote, "I damn near shot him," end quote?
I heard him say that.
And did you hear Abad say, quote, "I was about 2 seconds from putting bullets into his window," end quote?
I did.
Would it have been okay if Abad shot Mr. Griffin?
Objection, but you can answer, Sergeant Reese.
No, that would be based on the totality of the circumstances. I'm seeing a snippet from this video. Our intention is never to shoot anybody, but not knowing, I don't know why they were on this call. I don't know a lot of information about this call other than what I've seen in the video snippet. So I couldn't make a judgment call on that, whether or not it would be good to shoot, would be acceptable to have shot in that situation.
Well, let me ask you this then. At any point in the videos that I have shown you, would it have been okay for Abad to shoot Mr. Griffin?
I didn't see anything that would have said, you should go ahead and shoot at this time. But again, I didn't see the entire video. I heard the engine revving when Abad was approaching, but that's all I heard.
Based on the limited video that you have seen, it would have been murder for Abad to shoot Mr. Griffin, wouldn't it?
Objection. You can answer, Sergeant Reese.
Yeah, I would say at this point, he should not shoot. He should not have shot him, and he did not.
Now, do the words that we just listened to sound like the words of a police officer who treats people with respect?
I think that the words that Abad used were words that he felt at the time based upon the emotions of the situation.
is that how someone who respects people talks?
Again, it doesn't show a lot of empathy, if that's the word that you're looking for. But in the heat of the moment, officers say things that you may not agree with.
Mr. Kahn asked Sergeant Reese if that would be a lawful thing to do to shoot Mr. Griffin in that case, and Sergeant Reese confirmed that would be unreasonable. In the standard Graham versus Connor, 1989, the U.S. Supreme Court established the constitutional standard of objective reasonableness used to evaluate a law enforcement officer's actions. Under this doctrine, an officer should only deploy deadly force when a threat is imminent, immediate, and poses a danger of death or serious bodily harm to the officer or others. Because the body cam footage lacks any indication that Mr. Griffin posed an active, lethal threat, Sergeant Reese is forced to concede that firing into the vehicle would have violated Fourth Amendment protections against excessive force. Furthermore, under the 14th Amendment's Due Process Clause and standard policing protocols, the legal obligation to summon emergency medical services is absolute once a scene is secured, and a suspect in custody exhibits physical distress, claims an injury, or shows visible trauma. Sergeant Reese noted that instead of forcing the suspect to walk, standard protocol required immediately requesting a 4 or Grady, which is the department's radio shorthand for an ambulance to treat the injured individual. But since Officer Abad didn't really concern himself with Mr. Griffin's medical condition, he instead violated department policy by forcing the suspect to walk on what was later revealed to be a severely fractured ankle. These combined actions demonstrate deliberate indifference, which effectively can strip away an officer's protection of qualified immunity and exposes the department to severe legal liability.
Will you agree that these performance evaluations are completely meaningless?
No, I would not agree with that.
You won't agree to that?
I do not agree to that.
Will you please explain to me then, Sergeant Reese, why these performance evaluations don't reflect the defendant's poor performance?
Again, performance evaluations are a snippet of their entire year's activities. You would have to ask the rater whether or not he took this into account when he was issuing this performance evaluation.
Well, I mean, these are things that ought to have been considered when doing these performance evaluations, correct?
They would be taken into account when conducting a performance evaluation. It should be considered.
But we haven't looked at anything that would allow the reader to understand that there were poor performances, right?
I would say,
Sorry, objection, but you can answer, Sergeant Reese.
I would say based upon the fact that the rater did not give him a 5, he realized that there were some areas that needed some work. Every officer is like that, but I don't know whether or not Sergeant Davis took into account that when he issued this performance evaluation.
So you can, an Atlanta police officer can march around a citizen with a broken ankle and then still get a 4, which means that he's done a very good job?
Objection, but you can answer, Sergeant Reese.
I think that this incident should be considered in a performance evaluation. Whether or not it was, I do not know because I did not issue the rating, but it should be considered. It should be one of the factors.
Sure. Well, I guess what I'm asking you, sir, is whether it should be possible for someone to get a 4, which means they did a very good job, if they have done something like making a citizen with a broken ankle walk around on that broken ankle.
Objection, asked and answered. But you can answer again, Sergeant Reese.
I don't
If
have
your
anything
answer is
else.
different.
I really don't have much else to add to that. I think it should be taken into account and be considered. Whether or not it was, I do not know.
Sure, and I'm really not trying to badger you, but that is an answer to a question, but it's not an answer to the question that I'm asking you. And that question is whether you think that somebody should be able to get a 4 when they've behaved the way that you've seen in these videos. And just to clarify, that is taking into consideration the behavior that you've seen. Do you think that it's possible for that person to get a 4?
Same objection, asked and answered. Sergeant Reese, you can answer if you have something else to add.
I don't have anything else to add to my previous comments.
So the city of Atlanta thinks that the behavior that you saw in those videos warrants a very good job.
Again, I think that the performance evaluation is a totality of all of the officers' actions. Do I believe that there was area for improvement in this particular case? Yes, there was.
But there was nothing on those performance evaluations that said that these officers need improvement, was there?
Based upon the fact that they did not receive a 5 would indicate that there was room for improvement.
Let's look at the can you see plaintiff's exhibit 34?
I can.
So I'm looking at the key here, the definition of ratings, and it looks like there is a rating that indicates that the officer needs improvement, and that's a 2. And that's the officer meets most, but not all of the expected performance standards. Do you see that?
I do.
And then there's even one more above that says successful/effective. That's a 3. That says meets the expected performance standards on a regular basis, correct?
Yes, sir.
So if the reviewing officer intended to factor in this misconduct that you've seen and determine that they need improvement, they could have given him a 2, right?
He could have given him a 2.
But he did not give him a 2 in any of those categories, did he?
Did not.
If bad cops get good reviews, isn't it true that those bad cops look like good cops on paper?
Objection. You can answer, Sergeant Reese.
Yes, that is not what we want, and it would give that impression.
Would you agree that if bad cops get good reviews, the department needs to change something about its performance evaluation process?
I would say that if that is the case, then yes, they would need to review that.
Would you agree that if bad cops get good reviews, the department needs to be held accountable?
I would say yes, they do.
Sergeant Reese agreed that if bad cops got good reviews, the department should be held accountable. Pursuant to the ordinances of the City of Atlanta and the transparent legislative mandate of the Georgia Open Records Act 50/1870, the police department must hold its officers accountable by their actions. The department must ensure that its internal review systems accurately log operational failures, as failing to do so creates a false narrative. Sergeant Reese conceded that when abusive officers receive positive evaluations, it artificially sanitizes their public disciplinary records, masking systemic issues and legally establishing a custom of condoning unconstitutional force. When questioned about the officer's conduct, Sergeant Reese doesn't agree with the way the incident involving the injured citizen was conducted, explicitly admitting that there was a clear area for improvement. However, he firmly denied that this misconduct required a lower performance evaluation rating, such as a 2, needs improvement. Instead, he maintained that the evaluation could absolutely keep its rating of a 4, highly effective, because the score represents a totality of an officer's entire year of service rather than one isolated event. When department and officer misconduct is hidden from the public, the standard of true accountability is entirely obliterated, transforming performance evaluations into a shield of meaningless paperwork that protects institutional failures at the expense of public trust.
Hey, stop the car! 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 Get out of the fucking car, Atlanta Police! Get out of the fucking car! Get out the car now! Get out the car.
And Buchanan.
Let's go. Get out of the car. Get out of the car. Let's move. What are you doing, man?
What do you mean, what am I doing?
Tell me, what are you doing?
Wait a minute, hold on. Don't grab me like that.
No, hold on. No, hold on. No, hold on. You do not swipe my hands from me. Do you understand?
You got anybody else in the car? You got any weapons or anybody else? Go check the car.
Sir, do you think that Vickers was justified in his use of force in Plaintiff's Exhibit 1.2?
Objection, but Sergeant Reese, you can answer.
I'll say,
In your personal, I'm sorry, in your personal opinion.
as I was going to say, that is not how I would have handled the call.
So I'm sorry, would that be a no? Vickers was not justified in his use of force?
So there are a couple of things here. I would not have handled the call that way. I did not see in the video where there's the question about the hand swiping. I didn't see that. All I could hear was he said, "You don't swipe at me," or "You don't take the idea of him being pushed, him pushing his partner." But would I have handled the call that way? No, I would not have.
Do you think that that was excessive force?
Again, I would have handled it differently. I don't know whether I wouldn't have done it that way is the way I would leave it.
Sir, I'm asking you a very specific question though. Is that excessive force?
And I'm trying to be as honest with you as I can. I don't know. I don't know what he was thinking. I don't know if Vickers thought that he was going for his partner. I don't know if Vickers thought that he might have a weapon and he might be going back to the vehicle. I don't know what Vickers was thinking. Would I have done it differently? Yes, I would have done it differently.
Well, let me just narrow the question a bit. Based on what you saw in that limited clip, the limited clip of Plaintiff's Exhibit 1.2, was the force that Vickers used in that clip excessive?
Objection, asked and answered. If you have something to add, Sergeant Reese, you can add it.
And I don't have anything else to add. I wouldn't have handled it that way, but we are different individuals.
Is that how the City of Atlanta Police Department would handle that?
Objection, but Sergeant Reese, you can answer if you know.
Not really quite sure how to answer it. I don't understand the question, really.
Sure. Does the City of Atlanta think that it's okay for Vickers to behave the way he did in Plaintiff's Exhibit 1.2?
Objection, but you can answer, Sergeant Reese.
I think if Vickers believes that his partner is in danger, then he would use the force that he thought was necessary. Would I have done it that way? I probably wouldn't.
All right. No further questions for me.
During deposition, Mr. Kahn repeatedly questioned Sergeant Reese regarding whether Officer Vickers utilized excessive force during the encounter. Excessive force becomes legally excessive when the physical coercion applied surpasses what an objectively reasonable officer would deem necessary to mitigate a threat, effect an arrest, or overcome a suspect's resistance under the totality of the circumstances judged from the scene without the benefit of 20/20 hindsight. Rather than providing a direct affirmative or negative response, Sergeant Reese consistently deflected the question. While he explicitly conceded that the encounter was not handled the way he would personally handle a call, he refused to formally label the tactics as a violation of established constitutional law. In February 2022, Judge Thomas Thrash's court denied summary judgment for both officers based on constitutional violations connected to this case, with the excessive force and failure to intervene claims allowed to proceed to a jury trial and the remaining municipal liability claims dismissed under a federal court order. Judicial findings concluded that the officers engaged in multiple forms of constitutional violations, including, quoting from the findings, utilizing a takedown maneuver that constituted clearly unconstitutional excessive force and failing to intervene despite a close proximity and physical opportunity to do so. Additional findings included that the department maintained an administrative custom of deliberate indifference by routinely rejecting sustained complaints from civil oversight boards, that supervisors systematically overruled disciplinary actions to protect problem officers, and that the city issued a highly effective performance evaluation to an officer while an active internal investigation into his violent misconduct was still open. The findings also describe an incident during the arrest in which the officers followed Mr. Griffin's vehicle in an unmarked car without any police sirens, raised a service weapon to give verbal commands before identifying themselves as law enforcement and forced the plaintiff to walk on a broken ankle despite explicit notices of severe injury, prompting a nearby responding officer to later note that he had never heard a man howl like that in his life. Beyond this federal civil case, Officer Vickers was indicted by a Fulton County grand jury on 2 felony counts for aggravated battery and violation of oath, resulting in his immediate removal from duty and active criminal prosecution. As for Mr. Griffin, because the city of Atlanta legally distances itself from paying direct municipal settlements for individual officer misconduct, his legal path shifted toward holding the officers personally liable for damages. Following the removal of their qualified immunity, the civil claims moved forward to target the defendants individually, ensuring that any financial restitution would come directly from the officers rather than public tax dollars. Reflecting on the grand jury's decision, Mr. Griffin expressed immense emotional relief, stating that the indictment finally validated his innocence and provided a sense of justice after years of enduring chronic physical pain and trauma. This deposition provides a revealing glimpse into the police accountability process, illustrating how internal evaluation systems break down when department officials prioritize institutional self-defense over public transparency. During a deposition, the supervising officer is expected to provide objective analysis, and a high departmental rank does not create an exemption from acknowledging explicit video evidence of misconduct. Performance reviews are meant to accurately measure a subordinate's fitness for duty, not serve as a protective shield to insulate historical use of force violations from civil liability. Sergeant Reese's repeated deflections and persistent refusals to criticize clear administrative failures did more than stall this session. When a deposition turns into an exercise in bureaucratic evasion instead of a fact-gathering process, the focus inevitably shifts away from the individual incident and onto the cultural failures of the department. As this example shows, once that happens, the consequences can extend far beyond a single deposition, following the department and its officers into felony indictments, federal exposure, and a lasting erosion of public trust. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.